and we will see that all the people understand properly, because it is a 90% part of your medical law practice, and which is going to have a very, very good color. When I talk about Medical Council Act, which is definitely going to be another major act like criminal liability or a civil liability, like a criminal liability, civil liability, there is another law which is known as Medical Council liability, where suspension of medical registration or removal of name from medical registration is governed by respective medical council. So definitely, I'm going to have a more emphasis on that, because lots of cases are happening against my doctor in a medical council, and patient also wanted to trouble. So your support system are going to be needed to both the client group, and for the purpose of the same, since MCI has been repealed, that is Medical Council of India Act or Medical Council Act has been repealed after NMC has brought in a picture. So we are going to deal with that NMC laws, where National Medical Commission, how and what way they govern the education system, how and what way they govern the ethics and etiquettes under their law, and the new draft which has been already brought for the public objection by NMC has changed over, have got a lots of changes compared to the 2002 regulation, which is really concerned for all medical practitioners being a new law. You being a medical consultant, if you know all this, probably can be a great support to your all client, including patient, including doctor. Both the client are going to helpful. We be helped by your knowledge. So we are going to deal with NMC, detailed law of NMC. Yes, when opportunity comes, we'll definitely talk about NCIM laws also, because National Council of Indian Medicine, who have regulated their Ayush doctor, like Ayurvedic, Unanipathy, naturopathy people also are being governed, how they are allowing a modern medicine practice to these doctors, what are their aim and objective, what they think about their gynec practice of these doctors, how this has been challenged by the other speciality in a court of law, how the conflict of various councils can be brought under the domain of argument. Definitely, I'm going to deal. Let me invoke the ideas of yours or thinking of yours by giving a latest notification of DCI, where DCI is given, and because I was there in a talk of maxillofacial surgeons conference, been invited as a speaker, where this question was raised, because latestly DCI, the Dental Council of India, has issued a notification protecting their maxillofacial surgeon in a cosmetic practice, allowing them to use Botox, allowing them to do chemical peeling, which is a field of a plastic surgeon, or could be a dermat. I have raised a lots of hue and cry, because there is another notification issued by NMC to govern the aesthetic practice and hair transplant, and they have given a guideline to practice hair transplant and aesthetic practice. How these two notifications are impacting each other, how these people not knowing the law are being feared with these things will be definitely domain, because let me tell you, for the all learner here, all the four councils governed by the parliament have got equal rights in this country. There's nothing superiority or inferiority complex. NMC is not superior to DCI. DCI is not superior to MCI. So try to understand that all the four council, let it be a National Commission of Indian Medicine, or National Homeopathic Council, or National Medical Council, or could be a Dental Council of India. All the four have got equal footing of the law. So notification of DCI, notification of NMC, notification of NCIM, or notification of National Council of Homeopathy are going to have equal role unless being challenged as an ultra-virus. For your knowledge, let me tell you, when NCIM came with a notification allowing general surgeon of Ayurveda doctor to do 58 surgeries listed in that as a surgeon category, which covers almost 80 to 90% of surgery done by modern medicine practice doctor, has created hue and cry, because that council governs their own people who are registered with them, and NMC governs their own people. So for the purpose of protecting the rights of their people, since NMC is not superior to NCI, and NMC, under the NMC, the people practicing, because NMC cannot go against the government body. So the association of doctors have gone against that particular notification in Honorable Supreme Court, and challenge that notification as a ultra virus, saying that it is not coherent with the law, and now it is pending to all the bodies to come and give their evidences for allowing. And if it Honorable Supreme Court decides the matter, it becomes the law of the land, because rules and regulations framed by various bodies need to be in coherent with the law governed. So, since bodies are equal, they cannot overrule each other for the purpose of the same. Same thing happened with the DCI. Even if at all someone wanted to challenge the notification of DCI, they need to go to the court and challenge that this is ultra virus, and then only this can be protected. But all the concepts. So definitely you're going to know the laws of these people. We are going to have a elaborate discussion on Medical Council Act. So three major things which you are going to deal in this, which covers almost 99% of medical law practice, is going to be criminal liability in form of IPC and criminal laws, Consumer Protection Act in the form of rules and regulation and CPA Act and with the procedure, documentation, drafting, other things, and the Medical Council Act, including NMC and the regulation and ethics, where this is governed by all other acts which I'm sharing with you all. Let it be a pollution control act, or let it be a disposable act, or it could be a, as I said, a meteorological act, or various other acts which timely coming and elaborating to govern the medical practice will be dealt separately in every sessions which I come across and wherever opportunity is given. Every time I always request my people to vigilant, because it is not only a medical law which is formed by the central government or by the state government to regulate the health practice is important, but we also need to be vigilant about the laws framed by the Honorable Supreme Court or Honorable High Court in absence of the of the same, where we are going to deal with all landmark judgments of Honorable Supreme Court, which is treated as a law in this country in absence of ambiguity or in absence of different law. Let me give an example. The guidelines given in Jacob Matthew case, where for the criminal liability, since there was no rules, no regulation, no notification, Honorable Supreme Court has taken that as a consideration and formed the guidelines for filing a case of criminal liability against the doctor, where they made the procedure that it is mandated to take expert opinion from government doctor, preferably of the same field. If you see the law of consent, well settled in Kashmira Kohli's case, which is absolutely seen a clear picture. In all the ambiguity has been clarified about cross speciality practice under the case of Tanaka, where the cross speciality practice of thoracic surgeon and neurosurgeons very clearly defined, impacting across the country about the specialization part of hair transplant surgeon, or could be plastic surgeon, or could be dermatologist, or could be per se of a gynecologist anesthetic, will be defined under that case, very clearly defined. When I talk about the compensation part, well defined and settled in AMRI judgment by Honorable Supreme Court. When I talk about cross-pathy practice, about the two paths crossing over each other, the law is well defined under Mukti Archan cases of Honorable Supreme Court. It has again been well defined under the Poonam Verma's case, which been as used as the law of the country. It is clearly given a guidance. These are the laws. Very latestly, if you have read the newspaper of a New Delhi case where in hair transplant, the guy died because of hair transplant in the saloon. Case has gone up to Delhi High Court, and in Delhi High Court, the question came of regulating hair transplant practice, because there's no hair transplant surgeon. It's been defined under the schedule of MCI, which was amendment done for 2003, and there was no proper amendment. So there's no hair transplant surgeon or cosmetic surgeon to regulate the same body. The Honorable High Court has issued a notice to and summon to the respective medical council to come out with their own evidences to define that who all can practice so what. So once that judgment comes, it is going to impact the country altogether. So that is going to be another judgment. Like I said, the one case which I have got, that can MBBS do hair transplant surgery, to me, of Hyderabad case, which I could be able to argue in Hyderabad High Court, and it is pending still in Hyderabad High Court. And then I approached MCI, Medical Council of India. Those days it was suspended. and the body was there who have categorically said that MBBS can do. So that is another landmark judgment. Unless overruled, it is still applicable to the country that MBBS can do hair transplant. If Delhi High Court comes with some other judgment, maybe overruled this, but we don't know what judgment is going to come. So lots of things are happening in this country. When I talk about medical laws, so medical laws by and large governed by the major laws which you need to know, which is definitely going to be part and parcel of your journey of understanding medical laws in the course of medico-legal consultant, and many the minor and smaller law of various state laws definitely going to come. Like if I talk about Maharashtra, it is Medical Practitioner Act. Practitioners of the local state, same way Karnataka Medical Practitioner Act. So every state has got their own act at the state level, which governs the laws of that state when it comes to the state practice. And every state has got their own power to amend their laws. Like I'll give an example of Karnataka Medical Practitioner Act, where they wanted to bring a capping on a consultation fees or the hospital fees. The capping was introduced by Karnataka Assembly under Karnataka Medical Practitioner Act, where they have introduced the chapter, the section of regulating the charges of the doctor, but with a condition that it can be reviewed. So that's the reason why that has not been done. So still people are charging whatever they want, but it is under the control of the law. Anytime it can prop up and the capping can be done. Not only that, patient chartered bill, which is soon are going to be the parliamentary law, where patients' rights will be very clearly defined, need to be followed by every hospital and every doctor, are going to be seen a new color. But various states definitely have brought that under various act, where patients' right had been elaborated by various state laws. Same way, the local authorities, like a municipal corporation of various uh, state cities, has also been empowered to make a law to regulate their own council. So various municipal corporations are making a law for regulating health sector in their domain, and the rules and regulation, if not been challenged, then it becomes the law of that particular area, and respective municipal corporation definitely governs the state. Like allowing a practitioner to practice in residential area is a big question, or a hospital industry should have a separate entry and outlet, or all other factor, then all the structural law of the local bodies, the fire policies of local body, various other local laws definitely impact the medical practice at large. And that's the reason the importance of municipal corporation laws are always there. So whenever you are governing with any of the cases relating to municipal corporation, you need to refer that law. Latestly, a case of a diagnostic center came, which was related to taxation of machinery, the octroi or the local VAT tax or the local municipal tax, which need to be paid while importing the machineries or installing the machinery. In that ratio not paid, doctor has been issued for 23 lakhs rupees penalty, which is then for the learning that you need to definitely refer to local laws. It is not a medical negligence or medical law, but definitely if your client asks something to you, knowing that you are a medical legal consultant, because he expects from you that you should have a knowledge of a medical law, then in such a condition, it is mandate on you to refer a local law to understand that also. Like latestly, one of my client has received, he was having a chain of dental clinic, received a notice from a council saying that it is infamous conduct or unethical practice to do advertisement. So it becomes very necessary to see that can this body has got a power to regulate these people also, because medical council has got a power to regulate their doctor, their medical registration, but not a register of center, which has been a loophole and people taken advantage. But definitely it is expected from you to understand. Lots of rivalry cases are going to come. So many of the time, contractual liability cases are going to come to you. Employee has been removed from the hospital without paying any amount. Many of the doctors are going to ask you such a question. or various laws, contractual liability of e-platforms like a Practo and many other organization in telemedicine, their agreement will be shared by doctors to examined by you to guide them about the contract they signs. And like a law of torts where the civil law liability of damages are being enumerated are going to be the part and parcel of your journey of your medical law practice. So many of the time when something new comes to you, you're not aware about the law. It is requested to you to understand, read that, or discuss with medical law practitioner to understand more about that and can help a lot. So my friend, journey of understanding medico-legal consultant program is going to be very, very beautiful. Major laws are going to be definitely part and parcel to this, but subsidiaries laws or smaller laws or the laws regulating the particular medical practice definitely will be touched upon in various other platforms which you can be part and you can understand, enjoy the journey by becoming a medico-legal consultant. So lot to speak on medical laws because lots of hidden laws are there, which I may not uh, be discussing here, may not be having a much important that has not been touched. Does not mean that laws are not there. So laws are there for every aspect in this country. Everything being regulated. Your hospital sterility, your hospital disinfectant, your OT disinfectant, everything is governed by the law. Everything is governed, culture test, everything is governed by the law. So you need to know basics of all these things, how and what way such a things are going to help, how due care can be inaugurated, how the laws which spoken about due care to save the doctors in medical legal has been inaugurated. Everything is going to be the journey of understanding all this, my friend, and it's going to be a beautiful journey. I say it is a beautiful journey because I am in this line from last 18 years and I am seeing every day a new cases. Learning is new to me every day. I get a something new every day to learn. I enjoy the journey and I really wanted that all my co-partners or my learners or my colleagues know all this so that they can really help our industry people to protect themselves in the industry of the same. In the same journey, you're going to definitely understand the importance of training the paramedical staff, how paramedical staffs governing the things, how labor laws are impacting the hospital industry, how the compensation part is now becoming a new color, how once you have removed the employee goes to some union and trouble you or your client is going to be a new domain. I've got every types of cases, even simple pathology lab has removed one of the technician who went to some union and filed a case. I have got a case of a hospital where removed the nurse has filed a molestation case against the doctor to get the money, how or get the job again, how the people removed OT assistant and went to union and then filed a case not having a union of the hospital. I'm talking about the private unions and how labor minister or labor commissioner comes in a picture, how labor law troubles my medical practice. So everything has came in the domain of medical law. So labor law, compensation law, these are going to be the subsidiaries, which definitely going to be have a questions when you promote yourself as a medical legal consultant. So whenever any opportunity comes of getting such a question from the client, do refer, do discuss, so that you get the knowledge by handling the cases and you learn more in this industry to become a good medical legal consultant. So action is going to help you to become a real good consultant. Theoretical or a practical aspect makes a lot different. We are going to have all the discussion of every law with the practical aspect because how it has been handled, what are the need of handling the cases, what you know to know in handling the cases will be definitely going to be discussed during the domain of understanding these things. So my friend, journey is going to be really good for all medical legal consultant. Modules are going to be defined by the global people. People who are getting opportunity to get repeated, please take opportunity to repeat the courses so that it become more clearer to you with a repeat. If you can invest the time, people who are definitely a part of the journey can enjoy the journey. So every aspect is well defined. Modules, definitely global people are going to disclose to you all how journey is going to go. Major part of medical legal consultant program I am going to take personally, but all other medical legal representative program, only medical record I keep a track on that. Remaining will be taken care by all the people. Yes, medical record plays a vital role. Understanding auditing of medical record is another domain. Forensic audit is different, and normal audit for the purpose of medical legal is different. We need to understand that, and we need to know all this to protect your client, to defend your client. And naturally, if you are taking patient as a client, support your client all respect. So with this, if you got any